Our guest speaker today is Iven C. of Iven C. Law Corporation. He's with us already, and Iven's really experienced in the industry, and he will be able to provide us with some valuable information today. And we'll do another introduction after our update. So I think Richard's here. Richard can provide us with the update, brokerage update.
Yeah. Good morning, everyone. It's a nice day. It's a good speaker we have today. Ivan, hi. How are you? Yeah. Okay. Actually, I'm trying to talk about some of the usual like uh, things, when all the agent handling the deals and we find out something that we want to let them know, to minimize the back and forth emails to correct it. Just a few points every time. So today I wanted to say agent taking holidays must in writing inform Magsen office who and when someone is going to look after the business during the vacation. Because we have some of the other uh, brokers, agent trying to show your listing, and then, oh, I couldn't get a hold of him and stuff like that. So please, remember that. Talking about when an offer has been accepted, whether MLS or exclusive, with or without subjects, need to be submitted promptly to the office. And then exclusive listing will be somewhat restricted in the near future. So watch out for this change. And for pre-sales contracts, Maxon need the contract to be submitted to the office first, and then that means the file has to be opened first before the manager sign its commission agreement. Then it has caught into our attention that agents do not report pre-sale transaction until approaching the closing time. It is not a good practice to do that, and you may forget the deal, referrals or bonus earned completely 4 years later, or having difficulty obtaining necessary signatures from a buyer who is now out of town 4 years later, right? So please keep that good habit for all those pre-sale agents. And do not forget to use Maxon logo when you are doing advertisement. Yeah, that's been requested by the BCFSA, and we have to remember that. And when the purchase price has been changed in a contract of purchase sale, and the rescission amount need to be changed and initialed as well. Okay, the CPS, the last page at the end of the CPS, the seller's address, the final acceptance and rescission date must be entered. It is a bylaw because we need all those information. And it's a bylaw, therefore, it is not allowed for the buyer and seller to mutually agree to change or extend the 3-day period. There's no negotiation for this 3 days. It has to be 3 days. So if the buyers are thinking to walk out of a deal without paying the rescission fee, they could, after the 3rd day, by exercising not to remove the subjects and then walk away. For ID, like the FinTrack things, out of province corporation, how we know that is the real existing company? Because it is out of province. We have not easy way to find out. So we require certified certificates to be recommended. Okay, and also talking about the extra E&O, it is now $26 a month, and I hope Billy is going to update this a little bit more. Billy, are you there? Billy. Okay, so Billy is not coming in.
Hi, can you hear me?
Oh yes.
Okay. Yeah, we have negotiated with a an agent for getting the extra E&O for $2 million, and finally we are successful in getting the contract provided by Intet. It's a big company, Intet insurance company. So the effective date for reinstating the extra E&O for $2 million is September 1. So we have not charged realtors for the month of August, and we will start charging the collecting the monthly fees effective September 1 this month. Okay.
Okay, so that's that's an update. So let's jump into our presentation today. So again, I want to welcome Iven joining us today. Ivan's really knowledgeable in all different legal aspects. I believe he does wills and estate planning, business and corporation, real estate. I'll let Ivan introduce himself. And today, primarily, we will be talking about title search. Title search, we come across it pretty much in every transaction, right? It sells. But not everyone can say they know all about how to read a title search. And we want to dig a little bit deeper into the details and also talk a bit about title fraud. There has been some cases nationally and internationally where there has been some fraud, and we want to know how to protect our clients, either the sellers or the buyers. So Ivan, I'll pass the floor to you. Let me share your screen first here.
Thank you.
Oops, give me 1 second.
So I've prepared a PowerPoint for you guys, in which Maurice is going to put up on the screen. And if you ever wanted to, you can ask the brokerage. You can. I'm not sure who to contact. If Maurice, is it you? And then you can either send them a link to the PowerPoint if you wanted to.
Yep.
And they can also watch the video as well as. But you can do both.
Okay.
Maybe while you're getting it set up, I can introduce a little bit to myself to all your agents. I've been practicing real estate for perhaps 25 years now. So any time in which real estate comes up as a legal topic, I've practically touched upon it. I've done it. Foreclosures, partnership agreements, developments, pre-sales, assemblies, including litigation for constructive trust and resulting trust, dealing with family division and assets protection, and what do they call it? A fraudulent conversion. Types of property transactions as well. And not only just the basics of the real estate transactions, buying and selling and refinancing and private mortgages. So anything and everything with real estate I've actually had touched upon or dealt with or given advice on. So it's and for your agents, pretty soon you'll get my contact onto the next screen. Maybe you can move to the next screen, Maurice. Thank you. So there you have my contact. You also have my cell. If you, as an agent, has a question that you just need some little quick help on, you can text me, introduce yourself as a Magsen Realty, give me your ID card, your name card, and then I can probably help you. Don't give the cell phone to clients. If you do want to refer people to me, I prefer emails as a way of introduction. So that I can still clear out my time to help agents when they want to, maybe one thing they need in order to complete the contract and close the deal for the sale or buy. Okay. So that's my information there. There's a QR code. If you're able to scan it, you'll get my links to my YouTube page. I encourage you to follow it because I have a lot of content that I put up. On 1320 radio, I'll do the radio show as well as the different topics that I present and collaborate with different realtors and different topics. As Marie said as well, I do corporation law, corporate business. I also do wills and estates. So in the nowadays, maybe for another time, we can talk about estate planning and real estate, because a lot of clients are coming in and saying, hey, they want to have children help a child buy a house and contribute monies towards so that the next generation can afford to buy in Vancouver. How to deal and structure those types of transactions. I can help, and that predominantly the last couple of years is not just the will, but mostly real estate planning and how to transfer real estate to children without jeopardizing the control of the parents. Okay, so that being said, today there's actually two kinds of topics. As mentioned, I want to talk a little bit in depth about different types of things you might see in a title search and what they are. Not that if you ever want to pull it out and look at it and read it, that's good to do, but just so that you see it, you're not afraid of it, or you have an idea what it is. And so, not that you're supposed to give legal advice as to the implications of a particular charge, but at least you know what it is when you see it. Is it going to be an issue? Is it going to be a problem? How will the seller discharge it if you're acting for the seller? And if you're acting for the buyer, should the buyer be concerned or worried about it? And what are the implications of things that show up on title? Okay, so the first screen, if you can. The next screen, the question is investigating title. You do a search, it's normal, part of everything that you do. What are some things that show up? What are they? Should you be worried? Should the buyer be worried? Should the seller be worried? And things like that. Okay, and as I go through a snapshot of different items, I'll talk about them and what they are. But if you have a question about a title that you've seen, any of your agents, and you might want to bring it up. I saw this, didn't know what it meant. Will it be, how is it dealt with? How is it discharged? How is it removed? Is it difficult to remove? I can answer all those questions when they come up. Okay, so next slide. Now you'll see that there's some things you will see that's registered on title is covenants. What are covenants? It's like a Latin word for a promise, but covenant is like a promise to do something, to take an active, proactive step. A positive covenant, meaning you do something, you look after something, repair something, and usually it could be a way in which to, most common one is if you have a house by a river or a creek or have ditches in front that the city operates as a drainage, that you have positive obligations of the landowner who has a covenant registered to do something. Okay, such as maintain a pathway, the water line on a creek bed or a river or a waterfront. Okay, then you have restrictive covenant, which is the opposite, not to do something. So one thing is a covenant, the other one restrictive. So don't build on this property. You have restrictive covenants dealing with buildings or a certain height of certain structures, and that are to be followed and adhered to by the person who owns a property. So this is something that if you guys have any buyers who are looking to develop a property, it's important to look at these on title so that the buyer knows what are the obligations and restrictions they are to have to deal with the land. These are registered on title and therefore it's not just easily removed. Normally they're by government offices, and that's the most common ones, but you do have private ones as well. Easements is another thing, which is a kind of like a method or allows access to a particular property, usually by an adjoining landowner or landowner property, that allows it to do specific things. For example, quite often when you have two properties that are really close to each other, and there's not much of a division, no fence that could run through two different detached homes, for example. There's usually an easement allowing one landowner to go to the other side's land in order to repair or fix or clean or maintain one other side of the building, and vice versa for both. So easements and if you want to find out exactly what type of easement and what does it allow or not, you need to pull the document from the land title office to find out what is being allowed or not. Okay. So easement is like an access type of situation, not to do something or to not do something, but to allow for something. Okay. Next slide. Okay. Rights of ways is different than in the sense that it's for a specific purpose to allow somebody to access for a particular purpose. Rights of ways is a form of easement, but it's a right to access or use a certain part of that property for a particular purpose. Okay, it's like a right. It's in the sense that it's registered, but it's a greater than an easement, which is not continuously, not for anything and anything that's needed, or often rights of ways or unrestricted ways in which the other person who has it, like an adjoining neighbor, has abilities to use it, like a road. A road isn't just used to fix or maintain on the other side of the building or property, but you can use it anytime, anywhere, any place. So you need to, if you do have a right of way and it's registered on title, to find out what that is and how far it is and how big it is, especially if you have a buyer that in particular wants to build. And they can't build over a right of way, similar to like one time there was a right of way that I had a client who bought a house and found out that the garage was built on top of a TELUS right of way. The buyer, of course, did a survey and found the right of way, but didn't do a title search that would have found it. The seller had bought title insurance, but the title insurance, which I can talk about later on, covers things that are not cannot be discovered. So a registered right of way is something discoverable. Someone can see it, pull it off the land title office and check the size and location and where it goes. So it's not covered by title insurance if the buyer comes in and says, hey, wait a minute, your house garage is built on top of a TELUS right away. Okay. So, for that particular case, it took a year and a half after the sale with a holdback to negotiate with TELUS to allow the owner who bought the house keep that garage on top of the TELUS right away, so that if they ever demolish it, they cannot rebuild on top. So that took a whole long time to get an agreement with TELUS. And that's like if you want to have your seller client with something like that to avoid a $7,000-8,000 legal bill to negotiate an amendment to the right of way, make sure you know what that is and what it covers before you sell, or if you're acting for a buyer, to tell the buyer who's planning to build, hey, you can't build over this right away. Okay. Okay, so next thing is a statutory right of way. Now I mentioned BC Hydro, but they're more like TELUS, but they're like quite often government issued, government bodies with rights of ways, which I mentioned before as a right of way, but it's actually a statutory ones by the BC Hydro. But you quite often have private ones as well. So statutory ones, there are ways in which you, like I just mentioned, negotiate to deal with it, but quite often it's non-negotiable quite often. Okay, you have pipes, you have sewage pipes, and you have water drains, things like that. Those goes across different properties. Just got to be aware of it. In Richmond, of course, they have rights of ways dealing with the Aeronautics Act, so the planes can cross certain areas, and it's no right for landowners to restrict any of that. And then you might have, for those of you who do commercial purchases or mixed commercial/residential, you might sometimes see a lease registered on. So quite often when you have a tenant who is renting a commercial space, they can, if the lease itself is for a term of greater than 3 years or so, they can if it's no restrictions in the lease, they can register a lease against title to the land that gives the tenant certain protections afforded by having a lease that's registered. Now, the thing about leases on land is that quite often, 99.99%, quite often the tenants lease a commercial unit, they register it, then they forget. And then years later, they've left, new tenants come in, new tenants don't register a lease. Later on, years later, the seller, the landowner, sells the land, find out, hey, there's a whole bunch of leases registered and didn't even know about it. So one of the things that can be done in those situations, that if you get a copy of the lease that's registered at the land title office, concurrent with the option to, or the option to lease or the lease itself, if the lease has expired, there's ways to remove the lease even after the tenant has gone and many years have passed, to remove liens that are no longer effective. Okay, something you might see and you wonder. And if I was a buyer for commercial land, sometimes you have mixed commercial, like lofts, for example, commercial residential buildings. You might want to investigate title and figure that out and try to find ways to have that removed. And better yet, if you're listing a property, get an idea of what that is so that you can then tell your seller clients that, hey, this is at least the buyer who's going to buy it doesn't want anything financial, and at least it's financial, to remove it. So then you guys know how to remove it. If there's no way of finding who the tenant is and where they are, okay, there's ways. And if you have anybody have problems, then call me. Okay. Now the next slide, judgments. Now this is judgments and CPLs, called certificate of pending litigations. Now, the judgments, one of the things is that the property is used as collateral for something that was owed to somebody for no matter what. It could be related to the property, but at the beginning, when the first lawsuit was started, but in the end, now it's attached to the house, using the house as collateral to pay for a debt. It doesn't have to be a loan, doesn't have to be a mortgage, doesn't have to be related to the house. That at some point, somehow or another, the house is now collateral, and it has a judgment on it. So the thing to do in those situations, that's normally a judgment, is a fixed finite amount. So that's a good relief. Judgments are usually not open-ended, so that there's always a set specified amount, which can be paid off from the sales proceeds. So if you are acting for you're a listing agent and you get a title search and you say, hey, buddy, what's this? Landowner, and they said, oh yeah, I owed this money a long time ago. I don't want to pay them. They never touched me. We can pay them from the sale proceeds. Well, one of the things that you need to do is look at the judgment, look how much is registered on the Title IV. And then if it's a law firm that registered it, most likely there's going to be legal fees to pay on top of the judgment in order to remove that judgment off title. So if you're acting for the listing agent, then you want to make sure that you are a listing agent acting for an owner. You do want to make sure that there's enough from the sales proceeds to pay off that particular charge. You don't want to have it so that the judgment itself is with any legal fees that could be on top of it. Be more than what is the net sales proceeds after commissions, etc. Okay. One thing about judgments, quite often people who are collecting, trying to enforce debt, they put a judgment and then they leave it alone, because they think, okay, one day when the seller's going to sell, I'm going to get paid from it because I have a judgment registered. Beware that if you are the landowner, then you see a judgment and it's greater than 2 years since it was registered, you can apply to remove the judgment without notifying the person who placed the judgment on title, because time has expired. So, if you are acting on behalf if I acting on behalf of a client that's trying to enforce a debt by using that property as collateral and put a judgment on it, I got to make sure that I renew it every 2 years to keep that charge alive and not prevent a sale without my client being paid. Okay, that's something to know. Okay. Now, the other thing is called a CPL. It's very common if the house you're selling is under the subject of a foreclosure. The banks file a CPL to make sure it's noticed to everybody who looks at the title that this property is being in the process of being litigated in the courts. For mortgages, of course, is for payment of a loan, but it doesn't just have to be a mortgage, okay? It could be family law claim. It could be a constructive or resulting trust claim, a debt claim, a partnership claim, anything that deals with the property. Someone owns an interest in that property and it has to be notified before anything happens. Now, not all CPLs are alike, just like how I mentioned about judgments. Judgments are, finite. All you have to deal with is money, but CPLs is ongoing litigation. It doesn't mean that it's finished. The judgment is done. There's a set money amount owing. CPLs, there's quite often the amount owed is ongoing. There's an increasing amount as time goes on. It's not a finite amount. So CPL may be registered, for example, $100,000, but that is as effective as the time in which the CPL was registered. For example, a mortgage from a bank, they'll register a debt based on the mortgage that's owed, but it accumulates every day that the debt is not paid. So be worried that when it comes to CPLs, it's not just legal fees that you have to worry about on top of the judgment itself, okay? So if you're acting for a seller of a land property, you're a listing agent, and you see there's a CPL, it's important to know what type of CPL it is. Okay, so next screen. So not all CPLs are alike. So when it comes to mortgages and builders liens, quite often they're finite. Okay, there's the debt, there's a contract to fix something, to repair something, there's a mortgage that's owed. You can get the documents in which supports the filing and find out the actual amount being owed. Of course, then you have to, one of the things that I do if I'm acting on behalf of a seller is to reach out to the law firm normally that put the lien on, to say, hey, the date's happening for the completion. Give us a statement as to how much is owed. We'll pay it all off on you in exchange for a letter from that lawyer saying that they will authorize the release of it on undertakings for me to pay the amount owing. Okay. Now, the other types of CPLs, which are not finite, are, wills and estate succession act type claims, trust claims, family law claims, where the amount is not finite. And you may be surprised because the number is not normally set in stone. Okay, so it could be division of assets for a family law claim. And so it's like, who knows how much is being claimed, 50% of the increased value from the time it was first bought until the time of separation. It could be that claim based on contributions to the home, even though it's in the name of one spouse, but not the other. It could be contributions by family members, like the parents who help buy a house, in which they are also adding on top opportunity costs. Like if I didn't put the money into the house, I could have invested in something else and I couldn't this much money here. These ones are very difficult to quantify. They're more difficult to confirm whether or not there's enough equity in the house after the sale to pay out everything. So harder to remove if there's contested amounts. Okay, so family ones are the ones I'm worried about. Wills and Estates Succession Act, when there's a beneficiary to an estate and being sold by a house that used to own to someone who passed and they're going through probate. Those are very difficult ones. I would advise anyone who have a title or a listing where you have a estate matters or family law act matters to advise your clients to hire a lawyer before they sell the house to figure out what needs to be done so that you as a realtor do not get in between. Okay, quite often I have a situation where a realtor gets advice from the husband and gets advice from the wife, and they both say different things and no, don't do this or do that. And you can't tell by looking at the title search, but obviously, there's a family law act issue here, and pretty soon you might have a CPL by one of the parties. Quite often that's used by family law to prevent a sale or mortgaging or financing of a property before the dispute is resolved between the husband and wife. So one of the examples that I had before where they had a line of credit that was registered on the home, but with zero being taken off. And this is quite often when you get mortgages nowadays, a lot of banks want to offer, hey, you get a free line of credit. You can use it anytime you want. The limit is based on the paying down of the conventional mortgage. So 300,000 conventional mortgage, $1 line of credit. As you pay down the conventional, line of credit goes up. And so there's one client that says, hey, you know, the line of credit is like zero. We don't use it for anything. But there's a dispute between the spouses. So the other spouse decided during the separation to take out the 300 grand or 200 grand and use it to pay and fund their legal expenses. Now you have a joint family debt. The husband says it's not his. The wife says, well, too bad. It's registered on the house. It has to be paid off from the sales proceeds no matter what. Be wary of these things. This kind of calculations of strategic advantage with family claims happens all the time. You have a couple with that type of thing, and this also happens with wills and estate succession act claims. Be wary of beneficial people who are benefiting, who are in stands to inherit under a wills estate succession act that comes out of the woodwork and put a claim on saying, hey, I deserve a piece of that property. The will is not fair. I get only 10%, da, da, da. So be very careful. I'm saying that because CPLs is something very special. You need don't try to tell your clients about what to do and how to do it. And don't worry. You need legal advice when it comes to CPL. Your seller client, and even on behalf of a buyer client, you have a buyer client. Normally, you say, "Well, we don't have to worry about that. It's the seller's responsibility to clear title." But if you don't want any surprises, yeah, investigate. Tell the buyer to get some legal advice, to give them advice about whether or not a CPL that's registered is something that can be easily dealt with, or is going to probably lead to questions later on. If you are the listing agent and you have a CPL, a husband and wife situation, make sure there is an agreement, okay? Some kind of an agreement that deals with how to deal with a realtor. I like to put a clause in the agreements that I prepare called conduct of sale, similar to a bank. When a bank forecloses, they don't want to have the power to choose whichever realtor they want. They want to choose the lawyer they want and to be able to bargain in order to sell the property to pay off his mortgage. And I usually put a clause like that for family law agreements that gives one spouse the power of conduct of sale. So if it comes to sale, they negotiate, they sign the contract, they decide the price. The buyer comes back with a counter offer, or the seller counters back a request for a reduction in price with a different acceptance. Have all that power given to one or two, or make it very clear how that decision making is happening, so you, as the listing agent, can get clear instructions and not be conflicted. Okay, right. Next one, next slide.
Oh, Ivan,
Hi, yeah,
we
sure.
have a question from Arno on CPL. So why don't we slip that in while we're
Yeah, it's
on
good.
the
Well,
topic?
we're fresh on the topic. Arnold, yes, go ahead, Arnold.
Yeah, so Ivan's question was, he's working on a deal and found out the property had a CPL registered after the listing agents listed. The listing agents had no notice or idea. Is there a way to be alerted if a property gets a CPL registered during the listing period?
Yeah, good point. Now, lawyers and notaries have this ability, but maybe managing brokers, do you have this ability? Because what I do with some clients of mine, if I am concerned about any activities on a client, and we can talk about this later on because it ties in perfectly with title fraud. I can put a real Land Title Act LTSA notice alert for anything happening with the title, anything being registered. I'll be alerted with an email. It costs I think 60, 70 bucks to get that service done. And then they'll notify you if something happens to title. And this happens. So when you list the property, you stick that notice on the LTSA, they'll send you an email. They'll tell you if anything happens to it while you have it listed. Okay. Well, as not that, well, necessarily as you listed, but as long as you put the time limit and you put that notice alert on and register for it and pay for it, and then renew it every single time that you need to renew it. I don't remember how long it lasts for each time. But then you're notified if something happens, whether it's a CPL or not. Okay, so this notice will tell you any attempt to transfer, any attempt to mortgage, any attempt to file anything dealing with that property. You'll get notified of what it is and when it's done. Okay. And unfortunately, the CPL happens after listing. That's very, very common. In fact, I do litigation too as well, and I sometimes do that as a strategy. So one time I had a client who had a claim against the neighbor because they built a fence, and the fence was encroaching on my client's property, and it was being built up and being listed for sale. And I do a search on the property. I notice that, hey, there's clear title. Clear title homes are hard to enforce against. But if they're for sale, then they're easier because you want to target the time to put pressure on the owner of the house that's being for sale to pay off this debt, pay off the claim so that they can allow the claim or the conveyance to continue. And or else they have to fight this in court. Okay, so CPLs are quite often, sometimes not just for those type of situations, but for family. Okay, if there's a dispute, a CPL between two property owners is a good sign there's a dispute between the owners. Okay, if you act for husband and wife, you list the property, and all of a sudden you see a CPL by one of the parties, family law problem. Okay, family law claim. And the thing about CPL is that there is always a court case related to it. You want to find out about it, you search up the court case, pull out the filing claim, see what it's all about. If it's not a family related matter. Of course, if it's a family law related matter, you will not be able to get information because of privacy concerns. But if it's a CPL because of a debt or loan or a builder's lien, then you need to pull it out and tell your client, hey, if you're a listing, yeah, you better watch out. And again, just previously, the type of CPL matters. Okay, is it a constructive trust claim? Is it a resulting trust claim? Somebody says, "Oh, I paid money, but they promised to give me back my money when they sell," or "I had money, but I don't have no credit," and the other person had credit but no money, and then they put the money in the person with credit because they can get the mortgage, but it really belongs half and half to someone else. And these are types of claims that happens all the time. Okay. You want to look at that CPL, look at the lawsuit to see what they're actually claiming and see whether it's quantifiable. If it's a builder's lien, then you say, oh, it's for a doorknob. Okay. They're asking $10,000 for a doorknob. Yeah, okay, little suspicious. Okay. Any kind of questions, of course, get your client to get a lawyer to review it, to see if they need the lawyer's advice to deal with it, to file it, to claim it. To fight it, to negotiate with it. Okay, does that answer your question, Arnold? Arnold, I don't know which Arnold it is. Okay, there you go. Yeah. So, unfortunately, those things happen, and when it happens after listing, it's even worse. Your client is not telling you something sometimes, but sometimes it's really innocent. Like I did have a client that had a CPL and a builder's lien, and it was really like literally for a doorknob because they had a dispute and they didn't like it and didn't want to pay them. And mind you might botch your whole deal just because of something pops up. Okay. Now, one thing more before we move on to the next thing about CPLs is not meant to hold the house owner hostage for the purposes of a sale. Okay. Any type of CPL, there's a way to remove it, but it may be costly. That's the problem. Okay. If there's not a lot of time, there's 2 weeks left, you can still make a rush court application to remove the CPL. Normally, because a CPL is just one form of collateral for a debt. Okay. So you put the security in the form of money that's owed. Someone builder is claiming 100,000. A spouse is claiming 300,000. Whatever debt could be related to the house, a disgruntled family member, a beneficiary who says, I belong to a quarter of the value of the house. Well, sticking the money in court, CPL is removed. Now the money is collateral in court instead of the house. And 9 times out of 9.9, the courts will grant that removal of the CPL to allow a house to be sold. You just have to know the amount and the amount that the person who filed the lien is claiming for. And then they're happy, and then you go to court, you file it, and you remove it, and then the sale go through, and the money can be in the form of money from the sales proceeds to be paid into court. Okay. When there's a lawyer involved on the other side, quite often you can negotiate. So sometimes what I've done is I've reached out to the person who filed the claim. Hey, look, I'm selling this property for my client. You're looking for 300 grand. What if I keep it in my trust account? On undertakings to keep it there until a court order or a settlement has been reached. Okay. Mind you, if that's done, then it's actually easier than paying it into court. But the problem is if it does that, and I'm the one dealing with it, I charge to use my trust account to keep funds in my trust account on behalf of a client's claim. Okay, so be aware of extra additional cost, but it's doable. And the earlier you can resolve it, the better. Like if I know ahead of time, I have 5. I just recently had this client that had 6 CPLs, some from mortgage owners, some from other people. That I reached out to every one of these lawyers and I told them, look, there's enough equity to pay all of you. Just let me deal with the sale. I'll hold back the funds. Upon the sale, you get the money, give me a letter to release. Boom, we're all done. Okay. So sometimes it's a matter of negotiation. Sometimes it's not. Sometimes it's quick. Sometimes it's simple. Give me 100 grand, stick in your trust. Fine, done. Okay. And usually I tell my landowner clients who are selling the property, hey, do you want to spend another 10, 15,000 to make an application to remove it? Or do you want to agree to hold back the funds and it'll be like 2 or 3 hours of time to negotiate with the other lawyer? Okay. You choose. Other way, you have to pay a lawyer to take care of that. So sounds good? Okay, next slide. So agricultural land reserve is another thing you might see on title. Okay, well, next slide. Yeah, there you go. So some of you might deal with other properties outside in Fraser Valley and Richmond and Tsawwassen and Delta and Langley. You might see a little notation that this part is subject to the ALR. This link, this slide has a link that you can check out and find out what it is about this property, what part of it is, and what rules and restrictions they have with relation to this property. Now, properties under the ALR, the government wants to promote and encourage agriculture. So they would have certain things that promotes it and some things that prevents people from doing things that stops agriculture from being something that is done in that particular property. Okay. Now, I just want you, not only is it in it, what can you do with it, but next slide, you'll see a sample. If you go to that website and you've taken the parcel identification number, and it'll give you the little map of what it is and where it's located. Next slide. Yeah, and the affected parcel or parcel of land, and then individually it'll tell you what you can do. You can grow this, you can't grow that, or you can do this, or do blueberries, or have pipes and irrigation, etc. The next slide will show you some of the things where they are not farming, which they allow. In some sections, you have to read each one to find out. So home-based businesses, some pet kennels and breeding facilities, storage and things like that, aggregate extraction, sort of mining. if you struck oil, hey, great. I don't know. Quite often there's other undersurface rights you have to watch out for. Okay, so things to watch out for. If you're heading out there, you want to, and it's inside one of these ALRs, find it out, locate it, tell your clients what they can or cannot do. Next slide. So sometimes you'll see other liens, okay? Strata Property Act liens. Quite often it's used to enforce outstanding strata management fees or bylaw fines and things like that. And they're also something that's easier in a sense to remove if you're acting on behalf of a seller, because they're usually a fixed amount of money that you need to pay to the strata. And of course, when you are the buying realtor and you order a Form B, you'll see that there's a outstanding amount and there's a lawsuits happening, etc. And you can be alerted to that. Same thing if you're acting on behalf of the listing. Your listing and your seller client, and then I don't know anything, and then you see a Strata Property Act lien. They realize they forgot to pay their maintenance fees. They didn't change their bank account and then they kept trying to take it out from the previous account, and there could be issues there. Okay, and then another thing is called land tax deferment agreements. Quite often, you have seniors who are selling our properties. This is very, very common. The particular couple or husband or wife or a senior who owns a house has a fixed income, and they ask government for permission to, hey, can I pay my property taxes all at once when I sell the house? And they have a particular agreement set up. This land tax deferment agreement is registered on title, so that the property cannot be sold until the government has paid any outstanding taxes. And they're very quick. The government office that deals with this department, you ask for a payout on the day of completion. Within a couple of days, you get the number, the amount that you need to pay off. Now, just be careful though. If it's many, many years that the client has not paid their taxes, it can accumulate. It can be a lot. Every year you got 2-3 grand. 10 years later, it's like, 30-40 grand. And, they might have a mortgage they have to pay off as well. And, they're using this fund for their retirement, etc. If you're acting on behalf of the listing agent, you might want to get a sense of how many years they haven't paid the property tax. The buyer is going to require them to be paying off at the time of sale. So anyways, that's the land tax deferment agreement. Two more things I want to note, a couple more things. Notice of interest, Builders Lien Act. I mentioned something about a builder's lien before, but it's not, you won't see it in the charge section. You'll see it in the notation section, which before all the charges happen. So if you have a brand new property that's built and the plan is just registered on title and it's sold within the builder's lien period, you might see this notice sitting out there saying that there's a time frame for builder's lien to be filed. The time frame has not passed yet at the time in which the transfer is being attempted or the search is being done. And then you be aware. It's like a beware type of thing. It's not something to be removed per se. It's just a notice to any buyer that there could be a builder's lien claim coming up, and just be aware. So you might want to look at the timing of that registration, and then you say, oh yeah, is it 55 days later? Well, you're probably not 100%, but sure that no builder's lien would show up before the sale or transaction is going to happen. Next slide. Next slide, you have notice of interest, wills of state succession act. Similar to the builder's lien, there's a time frame for challenges to a distribution of estate after the grant of probate. Okay, so if a transfer had occurred and registration of some kind of transfer occurred before that time frame, which is 210 days from the grant of probate, this notation may pop up. Okay. And the land title office will need that grant of probate to do a transaction prior to that time frame. And so any transaction that happens before the time frame is up will have that notation on it. So, and the thing to do when you have the situation, you're acting on behalf of a buyer, you're acting on behalf of a seller, find out when the grant of probate was done and count the number of days in which you will be doing that transaction. And then you have a better idea of whether you're safe or not. So count 210 days from the grant of probate to see whether you should be careful or should be cautious or should be worried or not. Okay, so next one, Spouse Protection Act lien. This is something that a spouse can do on a matrimonial home, put a lien on the property to claim an interest because they're spouses. They don't need to file a lawsuit. This is something different than CPLs. They can put a notice to anyone saying, hey, an unregistered spouse is claiming an interest in the property that used to be their former matrimonial home. Okay, that shows up on your title. Then you better ask your, if you're a listing and the client says to you, I don't owe any money to anybody, and it pops up, then you ask the question, so there's a spouse who says that you're married, or, and spouse is defined as common law. So common law spouse lives in the home, leaves the home later on, knows the house is being sold, can slap one of these liens on. Okay, beware of that. So the next couple of slides, I just want to show you some things, what they look like. Okay, a covenant registered with the City of Vancouver, Land Title Act Section 2015. So that this is more like a City of Vancouver requiring things to be done, maintain the hedge or maintain and don't let the something erode, or, maintain the ditch in front of the house and don't block things up. Next slide. And then you see the right away from TELUS Communications. When you pull this document out, they'll give you the measurements of where it goes on the property, how far it extends, where it goes from. If your client gets a house and they do a survey, they can find out exactly where it is and how far it goes. Next slide. An easement and indemnity agreement. Now I look at this one because I highlight the word inter alia. So that means it's registered on more than one property. Okay. So a couple of neighbors quite often would have a pipe running through it, maybe a sewage pipe, maybe a garbage lane of some sort or something to that effect. Okay, just so you know, it's more. And if it's inter alia, just it's unlikely to remove it. So it's because it's registered against more than one property all at the same time. Okay. Now next slide. Land Tax Deferment Act agreement. So you see this, you see that it's Her Majesty the Queen and Right restricts dealings. So until the tax is paid, you can't deal with the property. That's what that looks like. You might see it once in a while. Next one, a sample of the Land Spouse Protection Act charge, the last one I talked about, dealing with spouses. Next one, you'll see a judgment, but you see the words renewed by, okay? So registration date 2014, renewed by certain date. You might want to look at the renewal date to see whether they've, 2014, it would have expired in 2016. Was that judgment renewed at any point in time? You got to take a look at it to see when it's renewed, so whether it's still operative or not, okay? Next slide, plaintiff builder's lien. You look at the time in which it's registered. Then you say, look, how many days have expired, okay? As the lien period expired, can the seller remove it? These are all different things that you need a good real estate lawyer to help with the client who has one of these filed to remove it, okay? There's ways to remove it if the time has expired. If there's an actual claim in court, then it's a different thing. The people who file liens on title with builder's liens, they don't have to file a CPL, but they can. It's extra money, it's extra cost. But just because there's a lien and you can remove it doesn't mean you're out of the woods, because the claim may have been filed in court and it's just not registered on title. Okay, so it deserves some time to investigate. What was the lien? When was it filed? What is it for? Has it been paid or not paid if you're acting for the seller? If you're acting for the buyer and you see this, of course, you say, hey, seller, you take care of it. But if you want to have an idea of how likely or how easy it is, it might be good to find out more about this claim. Next slide. Now, this is what an agricultural land reserve, it's not a charge, but it shows up in our legal notations. It's not exactly a financial charge. It's just a notice to the public about this property, okay, that is subject to the ALR. And then plan number 35. And the thing to do then is to go check out what plan 35 is, look at the registration and see what allows the buyer to do or not, okay. Okay, so that's my section on title. I don't know if you have, Morris, you let me know if the timing is good, because I can fast forward. I can go through my next section on title insurance and title fraud and identity theft, and when it comes to that. Or we can have questions, and we can always have time to do more interesting things about title and fraud and those things some other time. So you let me know. You tell me how to go, Maurice.
Yeah, I think we do have time. Obviously, the course is going to be for 1 hour. So we actually do go until at least 12:05 because we have the intro. If anyone needs to leave at 12:05, they can sign up. But I think everyone is encouraged to stay. Not too many slides left. We do have one question though. Do you want to answer that now or
Sure.
at the end?
Probably a good time right now. So.
Okay, so Jamie Cole asked about judgment. Does judgment have to be renewed before expiry, or still can renew for a certain period or time after expiry?
Yeah, so judgments can be renewed after the expiry. Like, the fact that it's 2 years past doesn't mean it automatically gets removed off title. That's the thing. The claimant who owns, say for example, the owner of the house notices that there's a judgment and it's 2 years past, and the person who filed the claim against them hasn't renewed. Quickly get a lawyer to remove it off title, sell your house, then you're done. But the person who filed the judgment realizes, oh my God, I missed it. They can file a renewal even after the expiry date. Good, answer your question. Thanks, Jamie. Good question, though. Okay, we should move on, right? Okay, awesome. So next slide. Now, Jamie, hope that answers your question. We can move on. Anybody has any of those type of issues, like, look at this. What on earth is that? How do you get rid of it? And just give me a text and introduce yourself. As mentioned, you met me at the digitally or virtually, or before we may have done a transaction, and send me your card, and we can go from there. Okay. So the next slide. Now, I want to talk about 3 different cases in which title fraud actually occurred and was successful in Canada. And one of that ties in directly with what Billy was mentioning. There's a question about E&O, and Richard mentioned something about companies and how to use FinTrack if it's an out-of-province company. The cases I'm going to show touch upon both of these 2 interesting situations that happened and how it could occur. Okay, so the first thing, there's a case that is from a couple years back, but it's important to illustrate the thing that continues to happen nowadays, and which may be harder, but it still happens. Now, this is a case that happened in 2009, but the very common pattern which happens in those situations which allows a title fraud to occur. So the plaintiff was the owner of the property, but someone was able to fake their identification, impersonated the owner, hired an agent using false IDs to pretend that they were the owner, sold it to someone who they paid money to pretend to be the buyer, who was also was unknown to the realtors involved, and they got fake IDs. And they managed to somehow got loans, private loans, not from chartered institutions, 2 loans registered on title at the time of purchase from private lenders A and B. And after everything was discovered that this fraud happened, the real owner sued to get his home back from the fraudulent buyer, was successful to prove that fraud actually occurred, the identification fraud actually happened, and tried to cancel the mortgages on title. The mortgagers tried to challenge, saying that, hey, we're innocent lenders. We didn't know that we're being duped. And what happened at trial and an appeal is that the mortgages got canceled. So the owner, who was a true owner, was able to prove real ownership, and it was fraudulently obtained, was able to cancel the mortgages. So basically, in this situation, I can talk about next slide. Anything that's less than ownership, such as mortgages, such as options to lease, options to purchase, things like these are not true ownership type of charges on title. They are secondary to ownership. Okay, someone proves that they really own the land, that it was fraudulently removed from them. They can remove anything that occurs afterwards, which is not different, that's less than ownership type of thing. Okay. So once proven, real ownership trumps anything other than things such as mortgages or other charges. Okay. Now the next slide. This is the actual segment from the case, and it refers to an actual paragraph in the Land Title Act, Section 25(1)(1), which actually does that for buyers or owners in BC. This is different than anywhere else in Canada. Every province has a different legislation that protects different buyers or sellers or mortgagers. But in BC, in particular, when you have a real owner, and that trumps and becomes more protected once it's proven, of course, against other things such as mortgages. Okay, so unfortunately, the lender A and B, they're out of luck. They lent all this money to this property, but they can't enforce and they can't sue the owner to get the money and try to foreclose. Okay, so that's important to know, because it's what are the consequences, who's important, who wins in some scenarios. Okay, so next slide. Innocent owner wins in this situation. Okay, so next slide. Another case, and this is a little bit later after this one, but it's important because it ties in with corporate ownership. And how things happen when it comes to companies. Do you have any client that you're listing properties with, and it's owned by a company, and you look at who the directors are, and you get the IDs, and you might think, oh, okay, that's great. I've got the IDs of the directors who's listed on the company register as a director. We're safe. Not really. Okay. In this situation, we have a seller, a person who bought the property using a company. His friend offered to incorporate the company for him. Let's just say that friend is no longer a friend. Okay. So incorporate a company, help the client, help the seller, the owner buy the property, but he retained the password to the corporate records office for that company. Okay. He went in and logged into the corporate registry, changed it to him and his wife's name as the directors of the company. Therefore, the owner of the land is the owner of the company, is the company, and who runs the company are the directors. So they take this and they go to the bank and they get a loan. Again, two private lenders, not necessarily bank chartered bunch, so the two private lenders who lent money. A and B lent money to the property, and they take all the money and then they take off. And then the real owner, who's the real director, who didn't know that he was removed as a director from the company register, is being foreclosed by the bank. So the lender says, hey, we lent money to you, you haven't paid back. And the owner, who's the director, says, wait a minute, I'm the director of the company. I never went to any bank to borrow money. And in this situation, they tried to cancel the mortgages. Now, there's a couple of principles here, which is why any we deal with holding companies and holding companies that own properties, you have to be extra careful, okay? There's something called the indoor management rule. So if the public searches and accesses the database as to see who the company's directors are, and they're entitled to rely upon that registration of who the directors are to believe in that as a real legitimate valid owner of the property, and based on ergo, who are the directors of the company. Now, in this situation, the title never changed. The company is always held by the same company, except the directors change. Directors change doesn't mean the title changes. So you can't tell by title if the directors change or not. You need to check the corporate registry. In this situation, then you realize, oh my God, someone hacked in and changed me as a director and tried to apply to cancel the mortgage. Now, there's a lot of suspicious circumstances in this situation, the amount being borrowed and clear title and all these types of things. But none of it was enough to invalidate the mortgage, because he was saying they should have known is not the right directors, et cetera, et cetera. In this situation, the court ruled in favor of the lenders, saying that they're entitled to believe who the directors are as registered and entitled to have a mortgage registered on the property. Next slide. Of course, in this situation, the innocent lender wins. The homeowner loses, okay? And this is a company situation. So next slide, sorry. So you have another situation where he proves that there's a fraud in terms of who duped the IDs, and not really duped the IDs, but went in and changed the corporate registry. They didn't win against the loan. Now we have a property, but with significant loans registered in which the lenders can now foreclose. Next one. The third situation, you have the situation that most recently occurred in DC, and where neither the buyer or seller it's not two parties being conspiring and being paid to dupe the other person, but there's actually an innocent buyer, a person who sees the listing, puts in an offer, and voila, they were first offer in, first offer accepted, which is a suspicious sign, okay? And below asking price, another suspicious sign. Well, maybe sometimes in some situations it's good, but whatever. Now you have an innocent buyer versus an owner who really owns a property, who had his real owner's IDs faked and sold. In this situation, now there's two cases in BC where that happened. Next slide. Actually, that is the slide here. And in both situations, and we'll talk about a little bit indicators of what makes a property more susceptible to being defrauded or not. But in this situation, two property were the properties were managed by property managers responsible for renting. It's clear title properties. Certain information was gathered that allowed the people who were pretending to be the owners to get information in order to fake their IDs and pretend to be the owners. They included forged false South African passports, copies that were accepted by all the parties involved, For somehow I don't see whether there's investigations as to how copies of IDs were accepted to go through the professional obligations of a lawyer or notary who represented those deals. I don't know how that worked out. But anyways, copies of ID documents were accepted instead of the original ones, okay? And if you have original ones, of course, later on, I'll show you some things about how to determine things, whether they look fake or legitimate or not, but neither here nor there. The point of me and talking about these two cases is to see who actually wins in this scenario, okay? Now, next two slides over, skip the next slide and go to the next one. And it says, in this situation, who wins? In BC, there's an actual case, not case law, but actual legislation at the Land Title Office. And they actually have actual wording. In this situation, where you have an innocent buyer and you have an innocent homeowner, the innocent buyer wins. Okay, it's important to know that, okay? The original homeowner can lose their home, but then has to have a recourse. They have to sue the dupster, sue the fraudsters, and apply for help from the Land Title Assurance Fund, which they have their own rules as to how you can apply for a fund if you've been duped up like this. But the innocent buyer, if they've shown that they actually, bought it and they hired a realtor, they put money in, they bought it, they got a mortgage, they get to keep the house, okay? The actual section of the Act, if you go to the next slide, is Section 25(1). And if you look at the Section 2, subsection A, in good faith and for valuable consideration purports to acquire the estate, that person is protected. Okay, so in BC has this legislation. It's different than other provinces. Other provinces is up in the air. Who fights what? Who gets what? But in BC, the presumption is the innocent buyer, and which makes that if you're acting on behalf of all the people who are buying properties, clear title, no mortgage, susceptible to fraud. If they're renting it, if they hire a property management company, this is a good situation to get title insurance to protect the homeowner and not the home buyer. Okay, if you're acting on behalf of the buyer who buys and then later on gets duped out of it. Okay, buy title insurance because it protects against this situation. Okay. Now, in nowadays, a lot of people are buying title insurance. Both the seller has it and the buyer has it. Then the title insurance can then negotiate what they want between the buyer and seller. Okay, and negotiate, not have to prove or fight and get winning and have a presumption of who's going to win. But in BC, just know that the innocent buyer has a leg over or trump over the original innocent homeowner. Okay, so in the next slide. In a situation in BC, the innocent buyer wins. Okay, so I give you these three scenarios so you have a sense of between the typical fraud cases that happens, the presumption and the protections that the BC, not different than other provinces, how they protect. Next slide. Now we did mention about typical targets, and warning signs. So if you look at the next slide, typical things, property with no mortgages, clear title, property with mortgages that have been registered for decades and nobody's looking at it, nobody's using it, nobody's paying it off, people forget about it. This is in particular with line of credit that's not used and it's just registered. The principal mortgage that the conventional is paid off, line of credit sticks around because it's meant to be for the buyer, the owner of the house to use whenever they need money, and just stays around. That's a good target. Look, nobody touches it, nobody looks at it. Good target. Okay. Another target, properties where the owner's address does not match the property address. Bingo, they don't live on the home. Property tax notices are sent to a different address. Properties that are managed by property management companies, properties that are listed on VRBO, Airbnb, or Facebook Marketplace, and any time where the owner is on the address or non-Canadian residents, okay? So if the fraudsters would search and research, they look at the properties on VRBO or Airbnb and they backtrack to the address and backtrack with the title search and find out that its address is somewhere else or address is clear title, then this becomes a target. Okay, this is a situation where you want to take steps to prevent things from happening. I mentioned earlier when one of the questions that are being asked about a judgment, no, a CPL being registered after listing, put one of these notices that anything being touched with the title on transfer mortgage that's not been authorized, then you get notified. Okay. So another thing to look at, next slide. Some things to look at or think about, and which makes the couple of patterns or factors which affects susceptibility to fraud when the client's stated occupation does not match a title search or the power of attorney, if you ever given one of those acting on behalf of a client. If the person couldn't remember the details of the mortgage that's clearly discharged off the title during the time that they own the property, if the mortgage person that's being used to get a private mortgage is not registered, and the amount of the mortgage exceeds the value of the home, any of these typical signs are not only warning signs but typical patterns in which it's a problem. It's something to be special attention. Another next page. The person has only one ID. The passport and driver's license expires on the same date because two different government departments, federal, provincial, weird that they're expiring on the same date. You drop the BCA DL when you get the original. It has a funny sound. Of course, this is very difficult, but you compare the two. And then photos and IDs are different types of IDs. Not only do they have the same expiry date, but they actually have the same clothing or different years apart. Address on the power of attorney, like I mentioned, doesn't match the address on any other document, and spelling mistakes on their own name. Okay, these are all typical signs, problems to investigate, and other situations where it may be a warning sign. Okay, now if something happened, steps you can take to prevent fraud from happening. Okay, next slide. Prevention strategies, things to alert yourself. So the first slide, of course, now not only homeowners, but if you're realtors and you're worried about CPLs being registered, you set up Google notifications by address. That means that someone is trying not to rent or sell or list the property on any other kind of social media. Okay, Google alerts allow that to happen. It's different than a title search one. Okay, Google is more broad. It involves any kind of marketing on some social media. You get a Google alert and on any property or topic and particular address, and you find something that they search and find some posting, and you get alerted to it. And I think this is only if you have Gmail account. So if you have a Hotmail or Outlook, it doesn't work. Okay. Second one, homeowners set up a land title activity notification. I mentioned about that. This is a specific to a land title office. I know that lawyers and notaries are allowed to do this. I'm not sure if there's any other ways in which to do it. Like it says here, each search and charge you pay for it lasts 180 days. So, hopefully your listing will sell before 180 days, but eventually you need to go longer. You can get another 180 days and pay for it. Anything pending, anything tried to register, transfer, Form 17, a lease, a mortgage, refinance, anything will be the person who registered it will get an email to notify it. I in particular have these notifications when I have wills and estates files, when I have litigation files dealing with foreclosure, when I act on behalf of private lenders, and I'm foreclosing on a property. I want to know if the client is trying to get some other type of financing, even if it happens after my judgment or my CPL. Okay. Another thing too, next slide, another suggestion is a private mortgage or institutional line of credit. Because the fraudsters target clear title home, as soon as they see a mortgage, they look for easier prey, easier things to go after, rather than a property with a mortgage. So you have an institutional line of credit, you have it, it's there, they're less likely to be a target for fraud, okay? Or you get a private mortgage for someone like your parents to the kids. I do that when the parents are financing their children's homes, even if they want to have the kids don't have any obligations to pay any mortgage and they don't have to buy it with a mortgage on it, they stick a private mortgage on it. I represent the parents. I put a non-interest bearing mortgage that's registered on the property, clear title property in their kids' names. And I put special conditions such as if the parents pass away, then the claim or the mortgage is forgiven, and then the client, the children will get a clear title home with no mortgage obligation. But there's a mortgage, but nothing is owed on it. So this becomes less of a target for fraudsters. Okay, last one. Not last one, almost last one. Number 4, next slide. Duplicate indefeasible title, which is a very drastic measure. It used to be the way the banks used to secure the mortgage on property. They take the actual physical document from the land title office and they stick it at a safety deposit box at the bank, and they hold on until the mortgage is paid off. It's never used nowadays. You lose it, it's a couple $1,000s to find a way to fix it up, to redo it and put it back into the title. Nothing can happen to the title until this is returned. I won't advise it. It's a very difficult one to keep track of, and people lose it all the time. You can take out the next slide. It costs, the cost wise from the land sale office is not much. 78, 17, you pull it out, charges may increase later on, but then you have to guard it with your life. Okay, don't lose it. Okay. Now, next slide. Now, there's other things that you can reduce the damage. Now, Billy, you mentioned about the great, you got new $2 million E&O insurance from Intact, which is great, which is awesome. Thanks, Billy, getting that nice extra insurance. Insurance always costs money. It helps. It doesn't protect against everything. It doesn't reduce or replace being careful. But it's sure nice to have if you need it. So thanks, you guys, getting extra excess 2 million E&O, because as you know, properties are a lot more nowadays, and the value of any liability is, greater than what your regular insurance provides. Okay, for professionals, okay, get 3 pieces of ID, don't get 2. Check all those things, check the picture, check the date, check the clothing, check all these things. And then title insurance also have services which they have, such as client identification verification. They do a couple of protocols where they send and check certain things and they pay money for it. And it's a service, not just buying title insurance, but paying title insurance companies to do verification of identity. It's extra cost, extra money, but extra peace of mind as well, especially if the person has, hey, I'm an out of province company. And so how do you know what's certified, and how do they register who the owners are? How do they know that? I know BC, but I don't know any other province. Okay. Next slide. Okay, this is a little similar vein about how to prevent, but also how to prevent, how to reduce the damages when things happen. Next slide. You get your buyers to buy title insurance, and you get your existing clients who own homes that you already help buy. Hey, I encourage you to buy title insurance to protect you against all the things that Ivan told you that might happen. Okay. And only lawyers and notaries can arrange for that right now. They haven't quite opened up title insurance to be purchased directly by clients, because they require lawyers to answer certain questions and things like that. So I do that service. If you guys have people or clients that need to, and you can quote me, and I can give you a quote how much to arrange for 1 or 2 or 3, 4 different properties to get title insurance to protect your homeowner clients. Okay. Secondly, the thing about what the title insurance can do, sorry, the other previous stage is that title insurance companies will fund the litigation, will fund the lawyers, fund the experts, fund the research, fund the fraud investigation to find out what happened, how to protect it, and ultimately to have the funds available to pay off. So, for example, an innocent buyer comes in and says, I don't want to give up my house. I bought it. I want the house. I put $100,000 of renovations. I want to keep the house. Title insurance can then, in that situation, negotiate on that point. And so that maybe the original owner who bought title insurance and can get back their house without having to pay for anything to fix it up. Okay. And then 2 slides over, I think, professionals. Next slide. Professionals, just as you mentioned, buy extra professional E&O. Lawyers will do it, realtors, you do it, mortgage brokers, you get extra E&O insurance. And the very last slide, okay, at the very last end, there's a fraud that happened, your title insurance, LTSA has the trust assurance fund. The problem about that is that they require a lawsuit. They require a judgment against the fraudsters. And if the fraudsters cannot come up with anything to pay at that point in time, at the very last end, then the trust assurance fund can be there. Okay. So it's not just, hey, buddy, I lost money, give me money. No, you have to sue and find out who the fraudsters are, sue them, get judgments, collect. They have to find out whether you've done anything to collect the monies or not. You can't, then they go back and then you can get the fund. So it's really complicated, takes a lot of time. And in the meantime, you may not have a house in order to get money from, in order to borrow money from, in order to pay for all of this, because it's expensive. Okay, so that's all my topic for today. Hopefully you learned a lot. Hopefully, if you have any further questions, of course, give me a call, talk to me, email me. And yeah, so there we go.
Thank you, Ivan.
Yeah, thank you, Ivan. I want to take this opportunity to thank you very much. Ivan is also the legal advisor of the Triple Chinese Real Estate Professional Association. And he's been very helpful to everyone and very knowledgeable and very good lawyer. Yeah, so take down his number.
Oh, yeah, you can go to the next screen, Maurice, and that'll have my next one after that, and you'll have all my contact there. So, and feel free, guys. Like, sometimes legal stuff is kind of boring. Sometimes I like talking about case law, and that's just me. But I have a YouTube channel. Feel free to subscribe and like, and you get new contents all the time and different topics being presented. All kinds of things. I have topics about foreign buyers tax and the ban and new things come up like the anti-flipping rule, the tax, the GST on new sales and builds, and sometimes I do collaborations with different realtors. So any of you are interested in doing social media stuff, reach out. I'm not that good myself, but if you got the camera and you've got the social media skills, I'm more than happy to work on something with any of you guys.
Just a quick note, Gavin. The QR code doesn't work in your card.
Oh, shoot.
Yeah, I think it need to be updated.
Oh my goodness, really?
Yeah.
What does it go to? I'm
It's expired. Is that expired or suspended?
Seriously. Thank you for letting me know. I will go check that out. So in the meantime, just use my cell.
Yeah, we will.
I'm sorry.
Yeah.
And maybe I'll do is before you send the link out for my PowerPoint, I'll try to amend the my slide. So Billy or Maurice, Richard, you guys get the updated one with the new QR. Gee, thank you for letting me know.
Thank you, Ivan.
All my cards have been handing out for so long. Here's the thing: nowadays, social media is like, oh my goodness, it's so much to learn, right? So I post something on Instagram, my kids will say, Dad, you didn't have music. And I put music on that I like, and songs I like. And then my kid goes, hey, that's so old fashioned. You don't use the new updated music. And you can't, there's always something to learn. So you young guys like you, Maurice, you tell us, you have to tell us what to do.
Thank you, Ivan, for the very nice presentation. We learned a lot from you.
Yeah,
and we hope to have you back in the future.
Yeah, likewise. Okay.
Thank you. Thank you.
Take care. Okay. Bye-bye.
Yeah. And for everyone, make sure you sign out with your full name and V number. And if you guys need Ivan's contact information, reach out to us. If you don't have a copy of the slide, we'll provide all that information to you guys. I think they were asking Ivan about your YouTube channel.
Oh yeah, so just type Ivan C. There's no other person named Ivan C on YouTube. Fortunately, nobody's faking my ID yet. It's good. And you signed up and you see the video link, and then you see my picture, and then you'll see all the videos. And I have podcasts as well as videos. So 1320 AM radio, they have a legal hotline show, which on Saturdays at 4 to 5. I'm there once in every couple of months or so with a topic. So that's all in Cantonese though. That's put up there, but most of the part is English and Cantonese. So and some estate planning stuff. And the last show was all about how to challenge a will. Not that everybody wants to do it, but so topics, wills and estates, business, all kinds of things. So hopefully you like and subscribe, because it's nice to have that so that I can continue doing content for that.
All right. Thank you so much, Ivan. And we'll invite you again for other topics.
Okay, take care, everybody.
Thank you. Thank you. Thank you.
Okay.
Thanks, everyone.
Bye, guys. Okay, bye-bye.
Bye.
Bye. Okay.